Hello and welcome everyone to our webinar on uncovering unrecorded debt and municipal liens in every real estate transaction. My name is Amanda Farrell. I work in the marketing department here at PropLogix, and I'll be the moderator for today's webinar. Before I hand things off to our instructor, Mandy Seckinger, I'm going to go over some really important housekeeping items. So this webinar is eligible for one CE or CLE credit in Florida for title agents and agent attorneys. At this time, it's not approved for continuing education credit in other states. In order to receive your credit, you must not attend the session previously in the past year. You must be here for the full live session, and you must be logged into the session under your name and a unique email so that we can confirm your attendance. If you don't meet these requirements, your request for credit may be rejected. After the webinar, we'll be sending out an email with the DFS form that title agents must complete as soon as possible in order to claim their credits. Florida attorneys, they will report their credit to the Florida Bar website, and I suggest that you do this as soon as possible. I'm going to throw up the number here on the screen so you can jot it down. We'll also be presenting this screen again after the webinar, and this information will again be in a follow-up email. So if you don't get it jotted down right now, don't worry, you will get that information later. On your control panel, you will find today's presentation in the handouts section. There's also going to be 3 polls presented throughout the presentation. So please be sure to share your thoughts. We really want to hear from you. Feel free to also add any comments that you have in the chat or question box. And we'll, if it's pertinent to the information that we're covering at the time, we will definitely share that with everybody. We want to try and make this as interactive as possible. If you have any questions, feel free to add them to that chat box or that question box, and we'll address them whenever we can, and we'll also hold time at the end of the presentation to address any questions that you have. So that's all I have in terms of housekeeping. So I'll go ahead and hand it over to Mandy.
Hi, good afternoon, everybody. Thank you so much for taking time out of your day to join us today. I'm very excited to have the opportunity to talk to you all about the differences between recorded and unrecorded debt as it relates to municipal liens. I am the Northeast Florida account manager, business development manager located in Jacksonville, and have been the certified CE instructor now for 3 years with PropLogix, and certainly am excited to have an opportunity to share with you another topic as it relates to our industry, and answer any questions that you have. And certainly I always tell individuals that participate on webinars with us, this is a two-way learning opportunity, not only for you to learn maybe something new that you haven't heard before, or maybe a refresher on a specific topic that's just good to keep top of mind in your business. But also, if you have an opportunity to share a certain unique situation that you've encountered in your day-to-day business that relates back to this topic, we certainly encourage you to share that by either in the chat or asking the question, giving us an opportunity to hear about any unique situations you've experienced and how you've handled them, so that we can all learn together as we move through this topic. Let's just kind of go over a little bit about what we're going to talk about today. We are going to hit on some very basic information. So if you are new to the real estate title industry, this may include some definitions or vocabulary that you may not have come across before. If you are a seasoned veteran, certainly this is going to come more as an opportunity to just refresh some of the specifics as it relates to Florida law. So we're going to define the difference between recorded versus unrecorded debt. We're going to talk about 2 specific chapters of the Florida statute as it relates to both utilities and code enforcement, and the effect that can have on a title insurance policy. talk about just what is a municipal lien, the components that we will uncover as we conduct a municipal lien search, and what the results of that means as it relates to buyers and sellers in the transaction. And then, of course, have an opportunity to wrap things up and answer any questions that you may have. So just as the general overview, this is a 60-minute course, and again, we'll just be talking specifically about municipal liens and how they differ from recorded liens. So recorded versus unrecorded debt. So we all know that at the time that a buyer and a seller finally comes to terms with a purchase and sale agreement, typically the first step that is taken with the real estate agent is to obtain the assistance from an escrow officer, a real estate attorney, or a title company to begin the process of doing the title search and exam of the public records. So typically it's to determine the property legal description, who owns the property legally, and find out if there are any claims on the property at the very beginning of the transaction. And typically either a title company or an attorney is going to conduct that very first step in accessing and reviewing the public records. So they research the vested owner, any liens, any loans, property taxes. All of these items are considered to be recorded. They're easily found in most public court documents, and it's the very first step in the process. So by uncovering recorded liens is very simple. It's so simply a request for information, and that information is presented pretty much, we have seen, in a very timely manner. Within 2 to 4 days, all of that information comes back to the escrow officer. The information is reviewed, and at that point, it's very clear and apparent to anything that may be recorded in the public record. So some examples of what you will typically find in the county clerk or recorder's office is all of the information that is part of the official records. So these include deeds, mortgages, judgments, tax liens, and these are all typically things that we consider to be voluntary, meaning that the owner of the property, it does not come to any surprise that the information regarding the deed on the property, the mortgage, if there are any tax liens, if there's any IRS liens against personal income taxes, any judgments as it relates to a divorce or situations such as that, it should come as no surprise that this information is in fact recorded and made readily available as a recorded lien. There are also several issues as it relates to unrecorded debt, and these are typically things that are involuntary, meaning that the current homeowner may not actually be fully aware that there are liens on the property, as maybe they have not been notified, or if they have been notified, it has been some length of time that has taken place. Or there could in fact be unrecorded liens on the property that are not found in the public record, that they're not aware of because it was not uncovered at the time that they purchased the property. So we're going to talk specifically about municipal unrecorded liens on property today, and these are going to be issues and instances where there are actually citations and fines that accrue, and they have to be sought after to be located in order for that information to be made available to all the parties involved in the transaction. These fees can build up into the thousands of dollars, and as we will talk in more detail, typically it's attached to the property. And we'll talk about the specifics about how that burden of those fines and those liens will in fact become the issue as that property may transfer ownership to the incoming buyer without them being aware that there is actually an issue if the municipalities are not searched for the information prior to closing. So let's talk about some examples of what that looks like. So some examples of unrecorded liens, liens that are simply held, documents are held, notice of the violations are held at the individual municipality offices within the county. Things such as outstanding charges from the city for numerous services such as nuisance abatement, grass, weed cutting, boarding up of abandoned property. So typically when you're talking about things of this nature, there has to be a reason why the city was called out to the location. It can be for a number of reasons. It could be simply that property owners have moved. They are not currently being managed under the supervision of an entity to make sure that the lawn is mowed, that the house or the structure is kept in some type of safety situation. And if the city or the county has to come out and remediate any of these issues, it costs the municipality money. So if they have to send someone out to mow the grass, or if they have to send someone out to board up the abandoned property, there's a cost associated with that. And typically what happens are those citations then are attached to the property. And again, if the seller has moved on, and the buyer is coming in and they're buying it sight unseen, they see it in the record, they're not checking or doing any kind of due diligence, you can see how easy it would be. These absorbent fees and fines can literally be overlooked and not be caught prior to closing. Code violations such as missing railings, overgrown trees, debris. So all of these, again, it could just simply be that a neighbor, next door neighbor, is the one that is simply complaining about the way the structure next door is being maintained. A lot of times you may even find yourself in a situation where, and it's not uncommon in the state of Florida, for there to be absentee ownership. Property that is purchased is for investment, and they simply use it as an income generating property by leasing it out weekly, monthly, annually. And it could be something as as simple as an annoying dog that continues to bark, and the neighbor in the condominium complex calls the police officer to come out and provide a warning or citation. That citation attaches to the property and becomes part of what we are calling these unrecorded debts, these unrecorded liens or fines that do show up if they are searched for. Unresolved fees for inspections or certificates, special assessments we'll talk about a little bit more in detail. All of these different types of issues can be uncovered when a municipal lien search is in fact conducted. So what is a municipal lien? So if we just back up and not assume that we all know what a municipality is, well, a municipality is actually different than actually a county recorder's office. So a municipality can be the county, it can be the city of, but the municipality is basically an area or a community office where they manage and maintain their own sets of rules and guidelines. To give you an example, Duval County is the county where the city of Jacksonville obviously is a municipality within Duval County, but we also have the city of Neptune Beach, this part of Duval County, Atlantic Beach, which is part of Duval County. So there's multiple municipalities that fall within a county in the state of Florida. So each of these municipalities have their own set of governing guidelines. And so when you're searching for municipal liens on a property, the lien is going to be a charge upon a property that's imposed, and it cannot be discharged or released until that fine or that lien is paid for. So a municipal lien is a charge or a fee that's imposed by the local municipality due to some issue or problem with the property. Municipal liens, again, are typically not recorded. They are considered unrecorded, and therefore it is a responsibility for us as part of due diligence to go out and seek that information to see if there are any of those citations or fines that need to be addressed, remediated, and also paid for.
Before we go on to the next slide, I'm going to go ahead and launch our first poll. We're asking if you perform municipal lien searches. Either yes, you do this in-house, yes, you have a third-party vendor like PropLogix complete these searches for you, or no, this search is usually not needed in your area or unsure. Just take a couple of seconds to fill that out, give us your feedback. We'd love to hear what your process is like. So far it looks like the majority of you, 85%, you do perform these searches, but you have them done by a third-party vendor like PropLogix. 12%, yes, you do this in-house. Only 1% said no, you do not perform this search, and 2% unsure.
Well, that's a very good indication, especially in the state of Florida, that this is becoming a more common practice. It is something that has not always been the case. And certain areas of our state tend to use different versions of a purchase and sale agreement. So not every real estate agent is going to use the standard FAR contract. I know in the Northeast Florida area, we use the Northeast Florida Association of Realtors contract that has different language as it relates to the legal requirement to conduct a municipal lien search. The Panhandle, and I believe even pockets of the southwest side of the state also has different variations of a contract. So it may vary based on what you're viewing from a contractual standpoint, if a municipal lien search is in fact contractually required.
Yeah, and I went ahead and put into the chat box, everyone should be able to see there's a link to a blog that talks a little bit more about municipal lien searches and how they relate to real estate contracts. Mandy, I know in the northeast part of Florida, the NEFAR, as is contract, they recently adopted verbiage under the title search portion to sort of delineate the request, the need for a request of municipal lien searches.
That's true. And so as we are seeing more and more opportunity to uncover that information, and just basically as it's stated is that if information is uncovered, then it certainly must be communicated to all parties and must be addressed or remediated as part of the contract at that point. So absolutely, it's very critical to just know what version of the contract you represent and to make sure that the information is collected and communicated accordingly prior to closing. So we mentioned that there's two sections of the Florida statute specifically as it relates to the ability or the right to place liens on property. In Chapter 159, Section 17 of the Florida statute specifically addresses liens placed due to unpaid service charges. So this section of the Florida statute gives any public works provider the right to lien on property should the public works provider not receive payment in a timely manner for utilities. So it is, and this is different across every area. So some of the utility providers are public providers, and some of them are private providers. What it is simply stating here is that whether they do currently lien on property today, or if they don't currently lien on property, like for instance, just referring back to JEA, the local provider here in the Jacksonville area, they currently don't lien for unpaid utilities. What they do is they simply follow the individual who opened the account and address the issue regarding their personal credit liability. But should they wish to change their policy or their procedure, this part of the Florida statute certainly gives them the right to place a lien on the property for any unpaid utility bills. What liens, such liens, when delinquent for more than 30 days. The interesting thing about this is that it actually puts the utility company right at the top of the priority list on foreclosure of a property, right up there with the mortgage. So it is something that absolutely they have the right to do, to foreclose on a property for unpaid utilities. Now, I haven't personally seen that. Amanda, you may have come across a situation like this, but this certainly protects the public works provider to ensure that they get paid prior to that
Yeah.
property.
And another issue too is, of course, this is part of the state statute in Florida that companies, both private and public, have the right to place these liens, but it does become an issue for homeowners, especially new homeowners who are in the middle of a transaction. And it also gives municipalities, there's some, gray area there as far as municipalities being able to also retroactively begin to place liens or begin to go after a new homeowner for utility charges are especially a big issue we see a lot when we do our research. It's usually some sort of unpaid utility bill that was never officially filed in the public record. That usually ends up being a big issue for new homeowners. And so I actually just shared a link to a blog that kind of explores this idea of how municipal liens, while of course the state statute gives companies and entities the right to do this, does it present some sort of unfairness to new property owners? And there's a case specifically in which you know uh, an investor was essentially, they did what they thought was their due diligence, but some issues came up where the city basically came back to them and said, no, you actually owe us this money, you need to clear up this debt. And it was something that should have come up in a municipal lien search, but because it was not officially recorded in the public record, there was some vagueness as to the enforceability of it. So if you want to read a little bit more about that case and kind of ponder on this concept of when does the lien become enforceable if it's unrecorded, that's a really great blog to look a little bit more into those details.
Thank you. So, and again, just to kind of follow up on this, as a title agent, the Florida Lien Search, Chapter 159 search is typically required of title agents for purposes of removing exceptions when issuing title insurance policies. So again, it is going to be considered an exception to the policy until proof of payment and remediation of any unpaid dues or unpaid bills are actually resolved. So it's one of those things that's sometimes it's difficult for new buyers in particular to know that when a title insurance policy is actually presented, that there is in fact an opportunity for there to be exceptions to the policy based on what is and is not completed prior to closing. So it is the requirement, the policy to then show the underwriter where the utility bills are in fact paid and cleared up so that that exception to the policy can be addressed. The other important chapter of Florida statutes as it relates to municipal liens is Chapter 162. Chapter 162 of the Florida statutes specifically addresses code enforcement liens. So a code enforcement lien may be recorded based on the authority granted to the local government under Chapter 162. And several things to note here. Again, we go back and talk about that gray area, that timing from when the local municipality has in fact issued a code or multiple code enforcement violations, and when they actually then may record those as recorded liens in the public records. So there could be a long list of liens that are sitting out there that have not currently been filed, that will only be uncovered if you go out and seek the information through a municipal lien search. So a code enforcement lien attaches to real property owned by the violator named in the lien in the county where the lien is recorded. So these liens are separate from taxes and will not show up on the real estate tax bill. So they're not easily found unless you are specifically looking for them with it at the municipality. These liens cannot be removed unless the fines are paid and the lien is released. And if the lien is for a violation of the property, an exception again to the title insurance policy is required. So evidence must be received from the county or the local government that the subject property is now in compliance in order for the release of any exception to the policy can take place or can be addressed.
Yeah, and the same issue that we see a lot with the utility liens where they're accruing fines or they're, unpaid bills that simply aren't being recorded yet in the public record, but they still can cause major issues for the new homeowner. And, you mentioned earlier high weeds and other things that the title, or not the title company, the municipality can go in and clear up those issues. So even if you do go on site to the property, even if you do take a look at it and everything looks fine, without asking for that additional information within the municipality department that holds those records, it's impossible to really know for sure if there aren't any outstanding fees or fines that just haven't been recorded publicly yet. And so that's a really big issue that we've seen in the past. In fact, when I was doing property research before I moved into the marketing department, I used to do municipal lien searches, especially in South Florida, and there can be a lot of issues that come up in properties in South Florida. And one property in particular, it was in Riviera Beach. Basically, the lot looked like it was a vacant lot. But actually what happened was the structure that was there previously was unpermitted, and the company, or I'm sorry, the municipality essentially deemed the structure to be uninhabitable. And so they hired a company to go in and raise the structure there and completely destroy it. So without asking Riviera Beach for that information regarding, any sort of code violations, building code violations specifically in this instance, it would have been impossible to know that that had happened because they had not recorded the lien on that just yet. And that was probably the biggest issue that I remember coming across as a researcher doing this type of property research.
Yes, and I mean, and it does, it comes up more frequent than not. One of the things too to keep in mind, specifically to here in the state of Florida, our code requirements have changed multiple times over the course of the last 10, 20 years because of our weather patterns, hurricanes. You think about all of the changes in our code requirements as it relates to windows and wind structure, things of this nature. So it is very important for all parties to know what the current code requirements are, and if there is a particular property that falls outside of the current code requirements, what the options are. That is typically the best time for the buyer and the seller to understand and know specifically what they have to work with, whether or not a property remediation makes sense to move forward with the purchase and sale, or if it is just simply cost prohibitive to bring a certain structure up to code. Those discussions really need to happen prior to closing when this information is made available. and we're transparent about all the information that is found as part of the record. Again, so the code violation, when a code violation is found, the enforcement board provides the owner reasonable time for correction. So typically, the information is presented to the seller, right, with a notice, either via mail, or there's a sticker on a window, or there's some indication that there's something that needs to be addressed. And if it is not addressed in a timely manner, that's when the clock starts ticking. Daily fines up to $500 may be applied every day until it's corrected. And so this is where you see that constant accrual of information. And this is actually one of the reasons why there's a delay with the department actually recording the lien with the county recorder's office. And the reason is because it's accruing on a daily basis. They're giving the seller or the current homeowner, the opportunity to remediate the issue or the problem before the final step is to record the fine or the lien. And again, the fines become a lien against the real property on which the violation occurred. And until the fines are paid, the lien stays with the property. So just keep that in mind. Very important part of the due diligence for sure.
I'd like to go ahead and launch our second poll. I'm curious to know of the audience joining us here today what your role is in the title production process. Are you a closing agent? Are you a processor? Are you an attorney? Are you a manager or some other executive in your company or other? Looks like the majority so far at about 45% of you are closing agents, followed by managers, 20% other. Be curious to know what that is. 6% are processors and 7 or 8% attorneys.
Very good. A good mix, but everyone plays a role in the transaction. Everyone is actually part of the process of getting that contract from start to finish done. And good to know that the majority of the audience here today are in fact engaging in doing municipal lien searches. So certainly definitely assisting the consumer, protecting the consumer on a very important part of the transaction. So to talk specifically about municipal lien searches, and then of course this group that is conducting these in-house, where you are conducting your own municipal lien search, share with you some of the suggestions as far as us as an outsourced expert, if you will, on conducting these searches. Maybe you'll uncover some additional assistance in what you're doing in-house. But a municipal lien search is research. It's research done on real property by looking through county and municipality records in the area where that property is located. So a full property report will uncover unrecorded liens, fees, and other issues that are not readily found in the public record. Again, we just continue to stress that these issues are attached to the property and will become the responsibility of the new owner if they are not resolved prior to closing. So what's included?
Yeah. Oh, sorry, I just wanted to add real quick too. And how this research is done, it's often a mix of different types of research. You have to, sort of rely on your investigative prowess. You have to use a little bit of Google research. You also have to be aware of what municipality departments have what type of information. I shared a link to another blog that talks a little bit more in depth on how to do a municipal lien search for almost free. Typically, a lot of this information is held by the municipality, and there is a paywall. Essentially, you have to send them in money, and you also have to be sure to follow their specific instructions on gathering that information as well in order to get it back in a timely manner. And oftentimes there is a third-party fee from the municipality associated with getting that information. So if you want to look a little bit more into the process of doing a municipal lien search, that is a good reference or good resource there. The big thing though about doing a municipal lien search is in certain areas, you have various entities that have the right to lien on a property on various different types of accounts. And even with utilities, what might be a straightforward search in certain areas of the country, in some places in Florida, there could be, the city is the service provider for water, but the county does sewer or some other combination of a bunch of different things. And so in order to totally confirm and ensure that you're getting all the information and all the due diligence, you really need to understand the nuances of each of those regions. Do you need the next slide, Mandy, or?
Yeah, next slide.
Okay.
Yep. So this is a list of all of the areas that are searched, what we consider to be a comprehensive municipal lien search. It does include searching for any code violations, special assessments, utility balances and unrecorded utility liens, open and or expired permits, as well as property taxes. And so again, by stepping into each one of these various areas to give you an idea of what you should be looking for, we'll start with code violations. We'll go to the next slide. Again, some of these may be apparent, it may be obvious when you're driving by a particular property or you're looking at a property records. High weeds, trash in yards, poor maintenance of the property, inoperable vehicles, trash, noisy pets, obstruction of sidewalks, roads and alleyways. So when you're thinking about code enforcement, you're typically looking at it just strictly as a safety hazard for the general public. That's typically what generates a code enforcement. A very interesting situation happened up in the Nassau County area, Amelia Fernandina Beach, several years ago. And this is typical because a lot of times I ask even real estate agents, like, do you recommend to, when representing your buyer or your seller, to go ahead and conduct a municipal lien search prior to actually listing your house? Or do you recommend to the buyer to ensure that they want to see the records, the information that comes out on a municipal lien search? And I had one agent just simply say, I don't do those on vacant lots. There's no reason to order a municipal lien search on a vacant lot. There's no structure there. And I thought that was, I said, well, here's a story. You can look it up. There was a situation where, a real estate investor purchases a vacant lot and pays cash and closes in less than 10 business days. There's nothing to do but just transfer the money and the title, ownership of the property, and off we go, right? Typically fast closing cash. They bypass a lot of the due diligence just to get to the closing table sooner. He went to pull permits and approved the property and found over $37,000 in unpaid fines and fees in code enforcement violation. And all that real estate agent, when was confronted, said, well, when I got the listing, I sent my crew out there because I had them mow the lawn, mow the lot, and edge the lot and put the sign in the front yard. So there was no due diligence done prior. So even though it may sound like it's maybe not necessary, they're not always. I mean, you can clean up a property and still have existing code violations on a property that have not been addressed. Getting back to the noisy pets, again, situation where if the information is passed on to a tenant and the landlord is not found and they are still the owner of that property, if those citations have not been addressed, those fines and those fees attached to the property, not to the tenant. So there can be issues that do in fact need to be resolved based on what you find when you do a municipal lien search. And then again, just sidewalks, roads, alleyways, cracked concrete, things of this nature, are all different areas for property ownership that does in fact need to be addressed to avoid these types of violations. Special assessments. This is an interesting one too, that you would assume that special assessments that are levied against a property would be typically found, in most often they are found as part of the property tax record, right? You would find that as an additional line item to the property taxes. And so you would typically pick them up as any assessments there. But what you don't realize is that there is still that window of time where our special assessment, where the taxes, fall within a certain time frame, and there could be the opportunity where those special assessments are not picked up on the current tax bill. There are certain sections where there are completely separate departments that handle nothing but managing special assessments. Special assessments are things based on new roads, street lights, improvements to sewer systems or stormwater drainage, water connections, water supplies. These are all municipal projects that have been approved, and there's a bill attached to putting these types of improvements in place. And typically the homeowners in that area that are going to benefit from the actual improvements to the property are the ones that are going to be assessed to help pay for that bill. So you can imagine if we don't uncover the special assessments that may be imposed, and there, like I say, there are certain offices that literally they can stick this special assessment bill in an envelope and mail it to the homeowner, and it's never found or easily found on the tax bill. So if that bill is going directly to the homeowner and they've been paying their monthly fee for the special assessment, but it's not actually disclosed as part of the listing agreement, or it's not disclosed to the incoming buyer that there are in fact any special assessments to the property, it can come as a surprise to the new buyer for an additional charge, an additional cost of purchasing the home that they did not realize or take into consideration when they were applying for their mortgage and so forth. So this is not one that should be overlooked or missed. It needs to be included as far as a municipal lien search results as well.
And Mandy, I wanted to take a minute to sort of clear something up, because a lot of the terminology that's used for a municipal lien search might also be used in another form of property research, like with HOA estoppel reports. Pamela was asking, do HOA fees show up on this municipal lien search? And the answer would be no, because when we're doing a municipal lien search, it's specifically about the government entities or the other entities, like private entities that provide water, utilities, or other improvements in the area. So it's not, if it's anything related to do with a homeowners association, it's not going to show up in a municipal lien search. You will have to be sure to go to the association and ask them directly for that information separately. And you will see terminology like special assessments used from associations, because just as government may pave roads or put in lamp posts or other things that help improve the community, associations will themselves, as private entities, provide those services, and they will then charge the people who are members of their association a special assessment for those amenities. So it's important to make sure you understand that while you might see the same terminology applied in different types of property research, they are different things, and you are asking for that information from different places.
Absolutely, absolutely. So yes, I mean, it's definitely important to make sure that you get all of that, all of the details from the homeowners association in addition to your municipal lien search as part of the overall real estate due diligence.
Yeah, and another point too, and Christopher, he says items being discussed today on this webinar do not show up on estoppel letters. So there might
Right.
also be sometimes too where your association does not provide water and sewer. Sometimes they do. I think typically they do, but I know that there have been some strange cases where that might not be the case. And so again, you want to be making sure that you are as a title agent doing this research, that you are aware of the area of what is typical in that area that you are issuing that title policy. Or if you are the homeowner or investor, you want to make sure that you are following up with a title professional to really understand the nuances there in order to protect your interests in the property.
Yes, that's true. Thank you. Again, just going back over what we talked about earlier regarding Chapter 159, Section 17, as it appears or relates to utilities and public works. It is just super important that you verify and you double check with every local public works provider to ensure that the final bill is collected prior to closing. Again, with more than over 400 municipalities throughout our state of Florida, each of them operate differently. Each of them operate and have a different set of requirements, whether they lien or they don't lien. The good news is that if you check it, then and they don't currently lien, that'll just come up on the report that this particular municipality or public works provider does not currently lien on the property. It's just good to double check. The other thing too to keep in mind is that I know a lot of times we don't take the opportunity to remind all parties that the best way to ensure that there's no other opportunity for the incoming buyer to be held with bills or with just headaches that are not theirs is just to ensure that there's that final meter reading prior to closing so that they can come in and see specifically that that bill as of this date is the final meter reading, because as we know, and it happens very frequently, as sellers move out and move away, they may have shut off the utilities and they may have turned everything off, but if that water meter is still running and there's a leaky toilet or there is a sprinkler head out in the lawn somewhere, or any other way in which that water meter continues to run and there's not a final meter reading, that is just opening up a huge can of worms for someone to have to deal with after they close. And it adds up and it can become a major financial burden to the buyer if it's not corrected prior to closing.
Yeah, and I dropped a link to one of our more popular blogs on this topic where the bottom line is essentially be sure to get that final meter reading, in order to protect the buyer from having this surprise. And uh, I would love it if you guys go ahead and share that on social. It's definitely something that a lot of buyers read and learn, and it's filled with some really good information and a scenario just like Mandy described regarding a woman who went to go turn on her water and found out that there were thousands of unpaid bills attached to the property. And I'm going to go ahead and throw up our next poll as well, because we've talked about, what we consider at PropLogix to be a full municipal lien search, and that usually includes an open or expired permit search. But oftentimes I know some people don't like to make those requests because that can basically open up a whole new can of worms as well. So I wanted to get your feedback here today. If you usually do a search for open or expired permits as part of the title commitment, do you feel like that's within your scope as a title agent? Let us know if you say no, it's out of your scope of work. No, it's not usually an issue for you in your area. Maybe you don't usually find that your customers or your clients are coming back with big issues related to open or expired permits, or let us know yes, and go ahead and share your reasoning in the chat. I'd love to hear more about that. So far it looks like the majority of you, about 52%, are saying yes, um, and then there's a 34% are saying no, it's outside of the scope of work, and 13% is saying that's usually not an issue in your area.
Yeah, and it's really, this is just, it's an area, it's not always a contractual obligation to uncover open or expired permits as it relates to the purchase and sale agreement. But it is absolutely something that if the information is available and you uncover that there are opportunities to see that there could be issues, then it is something to consider. It's something to look and make a determination if it is if it's something that you want to order and you have the information. Of course, if you have the information, you can disclose it to all of the parties involved. It's going to uncover several things. It's going to either uncover the fact that a seller has pulled permits, they had some interest in doing some type of home improvement project, and they either if the permit is open or if it has expired, they just never got around to doing the work and never closed out the permit. Or it could be something as serious as the fact that they pulled the permit, they did the work, and for whatever reason, it didn't pass inspection. And if it didn't pass inspection and it hasn't been remediated, and the inspector hasn't come back out and approved that, then that may be an issue that the incoming buyer would want to know. Why there was a permit pulled, the roof was replaced, but for whatever reason it didn't pass inspection. Goes back to some of those code violations that do come up because it didn't pass code when the code guidelines were changed. So there's a whole number of things that do come up, but it can paint a pretty important picture to the parties involved. There was also a recent part of the Florida statutes that was updated, which was good information for everyone, because as we know that if any of these open or expired permits were not properly closed out, then again they're attached to the property. And so for an incoming buyer to come on and say, hey, wait a minute, I came across, we have a new roof, but it didn't pass inspection. Well, it'll be up to the new buyer at that point to remediate the issue, have it re-inspected, and pay those fees and those fines. That's the first and foremost. But also, it's just good to know that if expired permits are more than 8 years old or older, still sitting there, the Florida statute has put out an update saying that will not convey. Those issues will not actually convey to the new buyer. So they'll automatically be shut down, shut out, and closed without any onus being put on to the new buyer. So that's another positive that came out, I believe, 2 years ago.
Yeah, and a lot of the responses that we're getting sort of reflect what you're talking about. Karen says that she's come across situations where we're expecting to see a permit because clearly work's been done, but the permit was not pulled properly. So that is a good headache to avoid, obviously. And then another scenario, I actually wrote another article about this that I dropped a link in the chat for you all, is it is also a good way to sort of check for any potential mechanic liens that have not yet been recorded in the public record, because depending on your state, contractors as well as subcontractors, anyone who's done any work on that property, whether you or the previous owner contracted with them directly, will have the right to lien on that property. And each state has different time periods set for when they can make that claim. And in this particular case, a couple, they closed on a property. They there was a title search done. They had a title policy, but they found out after the fact via a note left on their door that a contractor was going to be coming after them for about $27,000 in unpaid work. And so in order to sort of avoid a scenario like that, while a municipal lien search will not reveal a mechanic's lien, which would be recorded in the public record, what it can do is sort of help guide you on whether or not you should suggest getting a lien waiver in order to avoid having the liability placed on the new owner should that contractor or subcontractor come back and place a lien on the property.
Yeah, and then finally, property taxes. Property taxes are required to be paid in order to obtain clear title. So we always make it the recommendation to go back at least 3 years in the public tax roll, just to make sure that there wasn't anything that was left out or was missed in the most recent past. And so we say that 3 years prior is it's a good number to go back to ensure that there's nothing that is outstanding that would affect the property. So in conclusion, a title search, again, a title search, it does not uncover unrecorded liens, where a municipal lien search does, giving you basically an opportunity to share the information and protecting both the seller and the buyer. A lien search protects the seller by informing them of hidden information and possible liens that they were not even aware of. And of course, the buyer is protected from unpredictable costs that may be incurred after closing. Of course, and although it is not mandatory across all the various purchase and sale agreement contract requirements, you just want to ensure that if you don't obtain a municipal lien search, it could in fact result in some type of claim of negligence from the consumer. And just to avoid that, it's just recommended that a municipal lien search, as well as a title search, is conducted on every property.
So we've got several questions, and I'm going to go ahead and put up the screen again for those of you who are attorneys and if you need that number to report to the Florida Bar. But let's go ahead and go through some of these questions. The first is, can you talk more about the condominium 40-year recertification for Palm Beach and Miami? Mandy, I'm not totally sure if you are super familiar with those in that particular region because you're more North Florida. What we can do is I will be sure to reach out to our researchers that are currently working in that area and they can answer more of your question. But as far as what that is essentially in Miami, it's more so in Broward and Miami-Dade as far as I'm aware. I have not come across that in Palm Beach County very much, but I did do more residential single family searches, so that might be why. But essentially that certificate is recorded or is required in those counties if a building is 40 years or older. And so that's about as much as I know about those. But we can get you in touch with people on our team to give you more information about that, Nina, after the webinar's over. Let's see. Wanda is asking, where can I find the information in writing that permits over 8 years old do not convey to the new owner?
I can send that to you. You can Google it. I'm sure you can Google it. It was a recent revision to the Florida statute that was passed, and I want to say it was in 2018. Almost positive it was in effective October 1st, 2018. There is a revision stating that any of those issues are dropped after the permit is been on record for 8 years or longer. So Amanda, if you'll just make a note of who was requesting that, we can get that information out.
And Jennifer's asking about the CE credit form. Again, Jennifer, in a couple of hours, we will be sending out the follow-up email with that form. So be on the lookout for that. If you don't see that in your inbox, please be sure to email education@PropLogics as soon as possible, but that should be out to you by the end of today. Let's see. So Helen had a question. I believe in Marion, Florida, we can have county and city permits placed on a property, probably depending on the location of the home. I guess if located in the city or county. When ordering these searches, does PropLogics automatically search for all types of open permits, lien, or only search the correct city, county liens permits? How would we know the difference on the report? Does it specify city, county permit liens? So Typically, I can say from my experience doing the research, what we will do is attach all of the material that we get back from the city or county in the report so that you can see that for yourself. Um, I don't know, Mandy, if there's anything else that you want to add, but yeah, typically we do search. First, we determine what governing jurisdictions the property is located within, and then we do the proper process to request that information from each governing jurisdiction. I don't know if there's
Yeah,
anything you want to add, Mandy.
no, nothing really else to add. That's why it's very important that legal description, parcel ID, and any additional detail is added to the request because sometimes just searching based on the physical street address does not uncover all of the issues that we need to research. So again, that's just very important to provide as much detail as you have available on the property to ensure that we are in fact searching down to that granular level, the actual correct address information. Also, I just want to add for anybody that is looking for a copy of today's presentation for your records, we certainly are going to have a link available to you as well. So if you'd like to share this information with anyone in your office, please feel free to download the PDF file. There will be a link provided when we send out the DFS form, and feel free to have that and share that with the folks in your office as well.
Yeah, and for those of you who still have questions that we didn't quite get to, I will be sure to send those to Mandy or to the appropriate parties in order to reach out to you and sort of give you more information, follow up after the webinar today. So I just want to say thank you, everyone, for joining us today. Thank you, Mandy, for the presentation, and we hope you all have a great rest of your day. I do want to say also, too, we do have a webinar next week that is going to be on driving more business with better customer service. So there will also be a link in the follow-up email to register for that. So if you're interested in that topic, please join us. I would love to see you all there. And until next time, I hope you all have a great and safe day.